we're always really excited to have this opportunity to just get together and bounce ideas. And so, as with his session, I want you to feel free to jump in. The information, as he said, is really dense. My slides are even more dense than his. So what I'm probably going to do is a good deal of skipping around because some of the things that I will discuss we've already touched on, but be assured that you have all of the information that you need pertaining to this session in your PowerPoint to take back with you. And I want to say as a housekeeping note that there is a very vibrant parents attorneys community that shares ideas, supports one another, entertains venting, and really meets a good deal of the needs that parents attorneys have that we don't get ordinarily in child welfare community here in Michigan for some sad reason or another. And you can contact Vivek and he will get you on the listserv. The only requirement is that representing parents is some aspect of your practice, because we want to be sure that the folks who are involved in the discussions are people who really are interested in promoting effective parents advocacy, and we want to be sure that people feel comfortable in expressing their views and having that discourse. Okay? So one other housekeeping bit. You might need to correct me because I'm having a very difficult time seeing today. I left out without my glasses. And as I told Vivek, if you're under 40 years old, reading glasses is in your future, so look forward to it. The first 60 days is the most critical in representing parents in child welfare. It's really the most critical in child welfare period because you get the momentum going in the first 60 days. The first 60 days is where if you establish good rapport with your client, you're going to have that client energized so that your client can be motivated to get things done. You're going to establish before all of your opponents that you're a serious attorney, and that will hopefully elevate the level of advocacy on all sides. And hopefully you can get things done faster so that children, if they've been removed, can return home, and ultimately the case closes out faster. So at the very beginning, you want to conduct a thorough investigation. And that may seem absolutely intuitive and obvious, but what I mean is that you don't want to rely solely on what the department is providing you. It's difficult at the beginning because the department is going to be one of your primary sources of information. But you can't rely on the department exclusively, number one, for the obvious reason that the department is your opposing party. They don't have any interest in developing a case so that you can be successful. They have interest in developing a case so that they can be successful. And oftentimes they get the information wrong, not because they're bad or because they're somehow meaning to be vicious, but because they're developing the case with their objective in mind. You want to always be the person who, in the courtroom and in all other aspects of the case, is the authority on the case. You want to have more information than you might need in court, but have every bit of information that is relevant. And if you develop a reputation generally from case to case as being that authority, it's going to pay dividends not just in that case, but in other cases where you're coming before the same jurists, the same stakeholders, etc. So your goal is to know more about the case at every single stage than anyone else in the courtroom. When you get the information from the department, what you're going to be looking for is not just documents, but you're going to be looking really carefully at what it is that is contained within those documents. The documents that you should get in every case, there's a short list here, but one of the things that you won't have at the very beginning is the service plan. But as Vivek said earlier, the service plan is required to be created within 30 days. So oftentimes, before you get to trial, you will have that, well, you should have that service plan before you get to trial. And you might have some evaluations that you can get. Remember that privileges are abridged in child welfare. So even though your client may not want to go for may not want to allow you a previous evaluation to be released, the department will very likely have it. So you're entitled to have it too, and you can get it. You want to get every single document pertaining to your client that is in the department's possession. Anything that's relating to prior CPS investigations, any criminal history that they might have. Get your clients to sign a release, because as the attorney, you can say, well, I'm the client's attorney, and you can show that you are that you're appointed, or you can show that you have an appearance, but the agency's not going to give you anything if you don't have a release. And you can argue all day long about your right to have this information, but it's just easier to give them a release oftentimes, because they'll respect that. There's formal discovery and there's informal discovery. The formal discovery rules are under MCR 3.922. And this is a rule of evidence that a court rule that we often just completely overlook. We're so accustomed in child welfare to doing things by custom that we forget oftentimes that there is law that relates to every stage of the proceedings. And so you can invoke the formal discovery rules and so that you can get all of the information that you need. You're entitled to all written or recorded statements and notes. You're entitled to all written or recorded non-confidential statements made by any person with knowledge of the events in possession or control of the petitioner. You're entitled to names of prospective witnesses and to have a list of the prospective exhibits. And if you think that you can't get the discovery that you want, you can file a written motion to the court and ask that the court order the agency to get that information to you. You want to set a specific deadline in your request, because even though we have a court rule that allows us to get discovery, it's still a little vague. It's not quite as particularized as it would be in a criminal case, for example.
Can I ask you a question?
Yes, ma'am.
So the discovery thing was something I wanted to learn about today. If I represent a parent in an ongoing matter, and Edna represents the other parents, it's good times, and one of the parents has accused the other parent of sexual abuse, and the other parent says the other parent is making it up.
Oh, that
So
never
the
happens.
prosecutor's office, well, DHHS is not giving us any information about what's going on until after the parents submit to the polygraphs. And so they're kind of, Mesquite County. So it says here that I can get.
So wait.
everything that the respondent says,
You said until after the parents submit to the polygraphs.
which I-
Do you know in advance that the polygraphs have been scheduled, or are you finding out somewhere?
Our clients have called us and asked us if they should.
And I've told mine not to do it, but,
And the agency is saying that they won't release any information until after.
until
The
they
co-
investigate.
So,
Oh, this is an
Well,
ongoing case.
this complaint took a long time to even file because Mesquite County wasn't gonna pick it up, but Mecosta County said, hey, and the Mecosta County worker called and said, you need to investigate this.
So
we
we're-
don't really know an investigator.
so we're still at the very preliminary stage for your case, right? There's no adjudication.
Yeah, we've been here for a while.
Okay.
This case started like in January
About 2 years
last
ago.
year.
So the discovery rule is anticipated to apply before the adjudication. I haven't really thought about whether it applies after adjudication, but I would suppose that it would. I'm sorry?
Oh, I'm sorry, it's new allegations after discovery.
Oh, okay, the plot thickens.
I'm sorry.
Okay, so file a motion with the court demanding that the agency give you the information. And I would say in my motion that the agency is trying to coerce my client into submitting for a polygraph in exchange for providing my client with what my client is already entitled to. And just bring it to the court's attention. I can't imagine, well, actually I could imagine, but I don't want to imagine that the court wouldn't be interested in hearing about that and want to act on it.
You know, with polygraphs, the results are not admissible in court,
Oh, yeah.
but your
Mm.
Right, and they submit the statements. And they also submit the results. I've had it in other cases, not my client, but they've submitted results where it's whether it's they're found they're devious, or they can't make a decision, whether they're telling the truth or not telling the truth. And then the judge will always find against the client.
Now, when you,
Because they're at risk.
when you say that they are submitting the results, what do you mean? Do you mean that it's being admitted into court?
It's part of the to the court.
Oh.
DHHS report.
Okay, so now we're out of the adjudication, but we're talking about the dispositional phase where hearsay is admissible, but you still have foundational arguments, though. I'm not sure that I answered your question, though. Did I answer your question?
You know what
Okay.
she really helped with was just the reaction in the room, because I was nuts over it too. And when I started, when I started doing this work, it was like 2 months before Sanders, and when I popped in with the Sanders decision, it was like instant hostility in the room, and it's never gone.
They didn't like the Sanders
I
decision?
did not like the Sanders decision.
We've had 2 juries already.
I didn't get my jury trial, they decided to dismiss to give the discovery back.
That is a good question. And I think it depends on what it is that you're asking for in the discovery request. If you know that it's something that needs to be compiled, you might want to consider a week. We're talking about, right now, we're talking about the point between prelim and trial. So you don't have a lot of time, but you have some time. So it really depends on what it is that you're asking for.
And my ask is, do you have like, have a standard release form for a client to sign to include that, like
I would use the agency's form. See, what you have to understand is that the agency workers they work in a bureaucracy and they feel safe, and I can tell you this from my own experience because I used to be a foster care worker. They feel safe when they're operating within the parameters of already established protocols by the agency. So if you say, hey, I'm entitled to this, and here's a release, and you've drafted it, you're the parent's attorney, they already don't trust you. But if you say, I'm entitled to this, here's the release, and it's on their form, they're more likely to accept that. And yes, they're all online.
So, I've had some pretty heavy cases that come about that I've had to handle, but that seem to require, in my estimation, more than just reading the petition. And I have asked for discovery for the preliminary hearing, and I wonder if you knew any case law with regard to that, because I've had the prosecutor respond to me, do you have any authority for that?
Have any authority that you're entitled to discovery for the preliminary hearing?
Correct.
So I don't have any authority, but my argument would be, what's the authority that I'm not entitled to it? Because,
Well,
see,
look at the court, okay.
what it is, and I think that's a really good practice, because even if you don't get what you're asking for, the fact that you're asking for it, I think, puts your opponent on notice immediately. I'm serious about this. This isn't just going to be a walk in the park. You're going to have to do some work here. And if you promote that in the mind of your opponent, they might look more carefully about whether to settle, whether to be reasonable in settlement, maybe even to dismiss the petition. It never hurts you. I mean, I think that we don't ask enough for anything, and if you don't ask, you're in the same position as if you asked and the answer was no. So you're not losing anything by asking. So we're still in informal discovery. You want to track down witnesses, get information from your client, get information from the DHHS worker. By the way, a lot of these slides were drafted some time ago, and now foster care case managers are foster care specialists. So I'm being very serious when I say that. So we want to be respectful and call people by their titles, because you don't need to pick fights when you don't have to.
Before you
I was pointing to Betsy, because Betsy chuckled when their foster care
Phrase of years ago that we need to start calling it stranger care, not foster care, because it just gets them seething in their
Well, that's what it is. I like policy mythology. I'm using that one. Thank you, Betsy.
Yeah, I might borrow that myself.
So you want to get information from the department specialists and contact the providers that might be listed in the service plan, if the service plan is already prepared. Internet has just changed the game as far as discovery is concerned, because you can do so many things, or at least most of you can do so many things. I have some challenges with technology, but I know that it's possible to do so many things out there on the internet. You've got Google, you've got peoplesearch.net, LexisNexis. There's also VineLink, if you want to find out about criminal history and things like that. And use the parents' attorneys community. We talked just a minute ago about, well, I did, about the parents' attorneys listserv. Everyone on that listserv who responds to questions is very, very supportive, very generous with their time. They'll give you all kinds of resources, sample pleadings and briefs, et cetera, help you with strategy about all of this. You want to learn about the witnesses. I talked just a minute ago about the ways that you can find out about criminal history. And you want to investigate if licensing is relevant in your case. You want to investigate foster care licenses and group home licenses, because a lot of times the people who are witnesses in your case, good friend or foe, have licenses, and you need to know what the status of those licenses is so that you can effectively cross-examine them if necessary. So these are the ways that you can compel testimony and production of records. Obviously, with the subpoena, you don't need to make a formal discovery demand via motion, for instance, in order to subpoena, because attorneys can subpoena. Anytime there is an open case, an open litigation, the court's subpoena power is in effect, and attorneys should be using more of that subpoena option. There's a link here for a subpoena form. Shout out to the State Court Administrator's Office for the form. Thank you very much.
Why do you attach a release to the subpoena?
Who just asked me that? What was the question and who just asked? What did you say, Kim? I'm sorry.
No, not a problem. I saw on your note that you said attach a release, accompanying the release.
Well, I alluded to it earlier. We can make legal arguments about what it is that we're entitled to, and we'll be completely right, but the agency worker, the agency specialist is thinking confidentiality, 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 even when confidentiality is not an issue, even when something isn't protected by confidentiality. The specialists are so afraid to get in trouble about violating confidentiality that if you just give them a release, even if it's not really necessary, they're more likely to cooperate, even if you have the subpoena. They can read the subpoena and say, you are compelled to produce. They are not impressed by that. They're impressed by whether they're going to be fired, whether they're going to get in trouble with their supervisors.
There's also a certain class of documents that are protected under federal law and for confidentiality, and they specifically state that like an attorney's subpoena won't be enough to trump them. I'm thinking like substance abuse treatment records. They have stuff about like judicial, you have to go get a judicial subpoena, and so that may be another reason why you give a release in there that could help expedite things.
Are those the HIPAA laws?
There's HIPAA, but substance abuse treatment is separate. There's separate laws that relate to that as well.
So when you first get the petition, which is, typically 5 minutes before the preliminary hearing, right? You get the petition, you're looking at what the allegations are, and from the allegations, because we're assuming that the allegations relate to the jurisdictional standard under 712A2B, from those allegations you want to develop your investigation plan. Find out who you need to talk to, what information you need. You want to ask the typical who, what, when, where, how questions. What steps you need to take to access the information, and really to kind of develop a plan. I know many of us back in law school were taught how to develop a trial book. This is a lot like that. It will help to keep you organized. I can't speak to it from personal experience because I've never used one, but I've heard they're pretty effective. Okay, so we're going to do a really quick exercise here. I think that you should have in your materials the mock petition. And we want to break up into three groups. Groups of three. And just go through the petition, review the factual allegations, and develop an investigation plan. How much time do you think we should have, Clifford? We'll do it for about 5 minutes. Is it not in there?
No, I can't, I don't know where it is.
Oh, okay.
Is it in a PowerPoint?
Let's see. It might be. I'm wondering, can we put this up on the screen if I give it to you? He said no. It's not in there?
You have a hand back there. Yes.
While we're waiting, where do you get the information on checking the status of a child foster care license?
That's a good question. Paula, would BCAL,
Yeah.
would people contact BCAL in order to check the status of license? Because I know that it's public information.
The foster group home licenses information is available just on the DHHS website. If you go, it says search a license or find a licensee or something, or I can put their name in.
Okay.
I'll send a link to Skip
Let's get it. Okay.
to Tracy, and they can send it around, and then you put their name in, and it should pop up with the initial, investigation for the licensing, issuance, any special investigation reports. They don't put caps on their corrective action plans, but anything BCAL did with regard to that license will be a separate PDF on there that you can download. But yeah, I suppose if you wanted to pick up the phone and call BCAL, I bet you somebody would also direct you or answer your question. I haven't tried it that
Okay.
way.
No, it's fine. Thank you. So it's going to take about 5 minutes or so to get the mock petition. So we're going to move on and just kind of bookmark where we are with that in your mind so that you can very quickly, because attorneys have to be nimble, mentally nimble, right? We'll just jump right back to it. So there is an organization in New York called the Center for Parent Representation that's headed up by a young lady by the name of Michelle Cortez, who goes to events such as this around the country and shares her philosophy, I'll call it a philosophy, about approaching representation for parents in child welfare, and it's called Cornerstone Advocacy. And Vivek is a Cornerstone Advocacy, yes. Vivek's a very big proponent of it. It really doesn't add anything new to your toolbox, but what it really is an overview of how to approach a case, how to look at a case. So the 4 cornerstones are placement, parenting time, out-of-court conferences, and services. And if you keep those 4 things at the forefront of every hearing, at every stage, you're going to find that it will promote the outcome that you're looking for your family a lot faster and a lot more effectively. So parent placement and parenting time sort of go together, so we're going to talk about those right now. These are some of the statements that I'm sure all of us have heard at one point or another when we're first encountering a parent and they're despairing about the fact that they're separated from their children. I don't know if any of us has ever been separated from our children or been a child that's been separated from parents for any appreciable period of time, but you can imagine, if you haven't, what kind of anxiety that would produce. And what you want to do ultimately regarding placement is keep a child in the home with the parent if you can. The placement considerations are first and foremost keeping that child at home if the child can be safely kept at home. If there's going to be an out of home placement, you want to be sure that the child has connections has connections to most, if not all of the people who are important in that child's life, because that's not only good for the child, but it will also put the parent at ease that the child is being well taken care of. We almost ready? And most importantly, regarding the parent, it keeps the parent engaged. If the child is able to continue to participate in traditional family settings like holiday celebrations. If the child is with relatives, that's more likely to happen than if not. But if the child is able to continue to participate in family celebrations and family rituals, most of, if not all the time, that's going to occur if they are in the parent's home. So. Elizabeth, what we just passing it around? So if we can keep the child there, it's going to keep the parent engaged, or give you your best hope of having the parent engaged. And they're going to be motivated to to allow the child to stay at home. I think we've got the petition, so we're going to go back. And really quickly, let's get in our groups of three. It makes sense to do it at tables, but we have groups of 4 at a table. So if you guys could just situate yourselves so that you're in groups of 3 really fast, as if you're getting paid money to be the first to do it. Developing an investigation plan. Now, just before we get everyone's input on how to go about this, my suggestion is that you keep in mind centrally the statute for jurisdiction, because you need that obviously for an adjudication. You even need it at the very beginning of the proceedings with the prelim. So all of your investigation should be geared towards compiling facts that would produce evidence, or I should say evidence that would establish facts that relate to the jurisdictional standard, right? So what are your ideas? Everybody, don't raise your hands at once. Don't make me call on you either, Jennifer Rosen. Yes, Noah?
As a group, we focused a lot on the gun, trying to figure out, are there statutes about gun storage? Was it a legal or illegal gun? Did she have a reason to be afraid in her neighborhood to keep a gun? Was the door to the room locked and the kids warned about the gun, or was it just something there? Stuff like that.
Okay.
Because, I mean, in Nevada, there was that woman who had a loaded handgun in her purse and left her kid with the carton in. The kid grabbed it and shot her, and all that was legal, and nobody was punished for it. And then in Massachusetts, where I'm from, you have to store your guns in one place, the ammo in another, and both have to be locked.
Okay.
So there's, I mean, in the United States, there's a huge spectrum of gun laws, and I don't know the ones in Michigan.
On the US Supreme Court, you got a right to have a loaded gun in your house. Right?
And you don't have to have it locked up.
That's right.
And so right now we're identifying issues that give rise to what the gun laws are. But our focus needs to be on the statute, irrespective of what the gun laws are. We might be able to use the gun laws in our argument as far as whether what's occurred meets the statutory basis, right?
It won't be criminality and neglect in the home if it's legal.
That's the point. That's the point to get to, right? So yes, Kim.
So I think we kind of identified a couple things. First of all, with proper or improper supervision. Why were the kids at home and after school? These are things that we want to follow up with the client.
Mm-hmm.
Based on the jurisdiction statute. And what was her aftercare plan? So in other words, if she had an aftercare plan after the kids were home, did somebody leave? So it could have been that somebody left and she had no idea of that. And then the other issue was, where was the gun? Obviously, it's not illegal to have a gun. So now, I don't always rely on the petition for accuracy. So I asked my client, the client says to me, was the gun put away? If the gun was out in the open underneath the bed, that would not be good enough for neglect.
Well, let's stop right there. With that, you said that would not be good enough for neglect. And that's what we all think about, neglect or abuse, right? But in the statute that governs jurisdiction, is there anywhere where neglect or even abuse is mentioned?
Substantial risk of harm. So the issue is, if the children have access to a gun, which children have access to a gun under your bed, unless you keep your door locked, and they could be harmed by that, that could be viewed as evidence of risk of harm to the
No,
child.
it's substantial risk of mental harm. And
No physical.
no.
So let's.
Statutory ground is mental harm.
This is a really good exercise, because what we're doing here is we're really highlighting the distinction between what we do in practice and what the law actually requires. We've got the statutory basis right here on the petition, which is actually something that is somewhat unusual. I'm mainly in Wayne County, so I can't speak authoritatively about other counties, but in Wayne County, it's not all that common that the specific statutory provision that the agency is basing its case on is delineated in the petition. It's on the scale form, and rather than the specific subsection being identified, everyone knows that any of those subsections are up for grabs at trial. So here, what's cited as the statutory basis is MCL 712A2B2. And that's the parent's home or environment by reason of neglect, cruelty, drunkenness, criminality, or depravity was found to be an unfit place for the above juveniles to live in. Doesn't say anything about substantial risk of harm, right? But that's what we think about. Right, by the parent. There are other provisions where under the statute that allow the child to be at risk, I'm sorry, not at risk, but in the care of people other than the parent. But this one is specifically about the parent's home. And I think what we would need to focus on for this scenario, and I'm certainly open to other opinions, is criminality. So,
You don't think that I'm sorry, I was using subsection 1, but you don't think that by reason of neglect, you don't think that the court would make a finding or an argument could be made by petitioner?
no, I'm not saying that at all.
Okay.
I think they would. I think I would. But what I'm saying is we should focus very intentionally on the language of the statute and work back from there, rather than having facts and then working in the other direction.
An example of that, there's a great appellate case that wasn't even in the context of child welfare proceedings, and we'll talk about it a little bit later, but it's a Supreme Court case called Tennyson, which was interpreting a criminal statute that basically held that it was a crime to contribute to a child, being defined as neglected under 2B of the statute, and it was a guns and drugs case. And it's the type of case that, like, in all of our worlds, like, there were guns in the house, drugs in the house, like, we wouldn't blink twice about a court finding jurisdiction over it. But the Supreme Court sort of very meticulous, they looked at our statute 2B and ruled that that in fact wasn't grounds, it wasn't enough, because there was no nexus between the guns and the drugs and
Right.
what happened to
But
the
in
child.
this case, in your scenario.
Yeah, so this is
there a
different,
nexus.
but I think Tracy's overall point though is that
Yeah.
we just have to sort of make sure that we're looking closely at the language of a statute. Because these are all, again, we're sort of becoming strict constructionists, textualists, looking at these statutes saying that that may make sense, but we're still governed by what's written in the laws. And if the law doesn't cover it, it's not neglect. It's not neglect simply because we think it is. It has to actually be covered under something that the legislature has said.
So I think for this particular scenario, we're looking at evidence, we're going to be looking for evidence that would support a finding of neglect, would support a finding of criminality, right? I don't think the others apply, but I don't think they say anything about her being drunk. She could have been. Yes, ma'am.
With that, Tracy, we focused on finding out about the mother's alleged criminal record. So our course of action would be to just ask the client about her criminal background, but also see what's out there using Otis or iCheck or other methods. And also to find out about her prior history with Child Protective Services. So we could use that method that you talked about before, subpoenaing the department, attaching that waiver. Third Circuit, we can just go down and look in the file, and see what's there. But that's the approach that we would take.
So are you envisioning that the agency would use mom's Child Protective Services record or mom's criminal record to establish criminality?
Perhaps, yes, definitely the history would come into play, if there's prior CPS history, prior contact.
If she's been sent to abandoned or done improper supervision on other occasions, they can bring that in. So that may be the kind of CPS history. It also could have just been her ex-husband called in some report about her, and that's what's.
And remember, with the CPS history, that could be it could be formal discovery that you're doing through 3.922. You can also just send a letter to the department with a release attached saying, give me that stuff. With the criminal history, you got Otis, you got iCheck. If you know of specific police reports, you
Vinelink.
can FOIA them. Freedom of Information Act, they will get you the actual police reports, which will give you the substance of what happened.
And ask for all the recordings, the 911 tapes, and all the dispatch records, because you never know what they said. Those kids could have said, oh, Mama always told us not to deal with the gun, or we had to open it up with a lock, a key.
Mm-hmm.
You never know what the kids would have said to the police, and they could be exculpatory.
And remember too, regarding criminality, and I always think that this is pretty interesting, the juvenile case jurist can determine that a crime was committed, even though there's been no conviction. And that's completely lawful because the statute encompasses criminality. It doesn't necessarily mean that the person, that the respondent has to have been convicted of a crime. You might want to argue that it should, but it's not really required by the statute. It doesn't say the parent's home by reason of neglect, cruelty, drunkenness, and history or conviction of criminality. It just says criminality.
Yeah, we said the same thing about, we would look at the criminal background for mom, we would look at her CPS history, we look and see what has been substantiated versus what's unsubstantiated, because I think that makes a big difference.
Who's doing the substantiation?
The agencies, how did it go? Was it a case, was there just an investigation and they investigated, the workers investigated and it was unsubstantiated? So if it was unsubstantiated, then that's not substantiated, that's something that's different. And what happened with that prior matter? Did they get services and was it successfully resolved? We looked at that. We also talked about the interplay with the police. Let's see, what are the police gonna do? Are they waiting to see what's gonna happen on the neglect case before they decide to do something on the criminal case? We also talked about looking and seeing who else is in the home, and talk to the client. If somebody else is in the home and she's clean,
And let's look at, can we get services in the home, get counseling, and, you know, what's the detriment that's gonna occur to the kids by being, you know, there's already this tragedy that happened, this accident, but if you take the kids out of the home, are they even gonna be more, traumatized?
Mm-hmm.
When you say who is in the home, you mean who else lives in the home? Or
Like,
resides
or-
there, or, okay.
Or
We
had
could
access.
put the gun there without.
Yeah. Or is,
Were you going to say something, Paula?
Yeah, the other point that my colleagues here raised, were good points, were, it says 8 AM to 4:30 PM, moms at work. Well, were the kids at school with after-school sports till 4:15? You know, or were they home from 8 AM till 4:30 alone? That could be make a difference. And then I think what was the other point? Oh, yeah, is the little girl still in the hospital? She doesn't have to be removed. She's safe where she is. She's recouping in the hospital. And, you know, maybe there's these other mitigating circumstances that show you don't have to remove the brother from the home.
Anybody else? Yes, Shadika.
I'm sorry, maybe I took a different approach. I practice in Tri-County.
There are no wrong approaches.
Across Genesee County, and once any court hears that someone's been shot, a child's been shot, they're going to automatically remove them. So I would think that the game plan would be that you establish relatives. If our ultimate goal is to keep the children with family members, then you need to know that there's a father. You look at the last name, see if they both have the last name. You look at custody cases in the court to see if there are any custody cases in court, who's there, if they're mother, grandparents, anything. If somebody's been in the home, if not the relatives, if they have close friends or other extended family that can take the children, you would look at those things like that. I would think we went through the who, what, why, where type scenario, but you can't get to the other ones, in my opinion, until you establish where can these kids go other than foster care.
So what?
You know that the judge is going to send them.
So what I'm hearing you say is that the inquiry, the investigation should produce information that is more broad than whether the court's going to be able to get jurisdiction. Because very likely the court's going to take jurisdiction under these circumstances. And you're still trying to get a good result short of that, like placement with relatives or maintaining the child in the home.
If you do try it, though, you want to do a motion limited against paragraph 5.
Ah,
Yeah, because those are in every petition, and many of them would not be legally admissible evidence.
that's a good point. Anybody else? Nobody else? Yes, Miss Tracy. I love her name. Doesn't she have a wonderful name? Tracy. She doesn't spell it right, but
well, our big question was, where's the father or the fathers? You know, is there a putative father? Is there a legal father? We want to find out from the mom who the father is, where he is. Has there been a legal paternity established? Is there a child support case? Is there an affidavit of parentage? Because that father could perhaps be appropriate for placement.
not only that, but his relatives might be.
Right?
And do we want to limit our inquiry into the father only to asking the mother, who is very likely, because she has all the scrutiny on her right now, not too anxious to give information about someone else who might be an option for the child's placement, especially if she and dad don't get along. So who would know who the child's father is? Who would definitely know? Children usually know. So we might even want to talk to the children.
I find that I don't have access to the children on a preliminary basis, and I do find that my clients are forthcoming with me because they understand that it's a dire situation. So, and I don't see any allegations against father or putative father who's potentially abandoned the children. So it could be a Sanders situation here. So.
Absolutely.
Yeah.
Yep.
The agency, the court has an obligation to require.
Yes.
But do they do that? Do they do that?
Yeah.
They rely on the mother, and if the mother says, oh, he's never seen him, or he never visits, well, is it because mom never let him see him, or let him know where, or we've had that problem where mom has totally prevented any relationship with the child.
Mm-hmm.
She lies quite a bit.
Okay, so,
Oh, and of course,
That-
there's an equine myth box.
yes, yes. Did everybody hear what she just said? Did everybody hear what our newbie just said? Say it again.
And of course, we wanted to know about equine myth box.
Very, very critical.
The only thing that we talked about that I didn't hear was verifying when she was actually at work, and it would be interesting to know whether she works at a drug testing facility too, that White Battery says.
I think somebody did touch on what the time frame was for her being at work, but yeah, the other,
Verifiable if you get time enough.
yeah, yeah.
Just so you know, the real case was in Washington DC. It was a snow day, kids were off from school. Mom's boyfriend was supposed to watch the kids. She had a job, he was on his way. It was a job that she had just started, could not be late to work because she was afraid of losing the job. She left the kids home, expecting the boyfriend to be there. In the intervening time period, the kids were messing around, found a gun under the bed. Mom had no idea that there was a gun under the bed. It was a boyfriend's gun, who had quite a lengthy criminal history. She did not know of the criminal history. We were all amazed that she did not know the criminal history until you see the guy and you're like, man, he's sort of put together. Like we were actually shocked that this guy who hid for a while in the case came and he presented just phenomenally, but he had a drug history. And the kids were removed, put in foster care for a short time, but the fathers all checked out. The kids were with the fathers. Eventually the kids were all reunified. The criminal case against mom was dropped. But all of this happened after boyfriend came to court and basically fell on the sword, saying that he was the problem. So that was how it
Were the
ended.
kids actually alone all day long?
No, boyfriend was there for most of the day.
Wow. Okay, so we have talked quite a bit already about parenting time and placements, especially with respect to relatives. So in the interest of time, I'm not going to go into any more detail about those things, but I will say just as some parting notes, become very familiar with the foster care manual, FOM 722-6, because it is just chock full of policies that support relative placement and even maintaining children in the home with the parent. And all of the manuals are online. They're very easily accessible. I would also say to keep in mind that all of child welfare is governed at the end of the day by federal law, because it's the federal law that gives the money for the services. And so the Fostering Connections Act has a lot of provisions that will help keep kids, at least with their siblings, help keep kids with relatives, and keep them tied to their school community. The McKinney-Vento Act also is directly on point with respect to keeping the child in his or her then current school at the time of placement. Let's see. And even though we haven't done trial yet, we're still preparing for trial. It's the foster care manual that is going to be the most, that you're going to find the most guidance and most authority for making these arguments in, because the foster care worker, the foster care specialist, governs what happens with that child's placement. The Child Protective Services specialist investigates the allegations of abuse or neglect, or the allegations that give rise to jurisdiction. And although it's the focus is on the Child Protective Services specialist up until and including trial, the foster care specialist is in the background working with services and with placement, and you can't lose sight of that. So it would be the foster care manual that's still governing everything with respect to placement. Okay, so parenting time considerations. You want to be sure that it's not only frequent, but that there's quality parenting time. We've been hearing for years, I don't know who coined the phrase, quality parenting time, and I would always say, well, that's just an excuse for people who really don't want to spend any time in terms of actual time with their kids, but that probably isn't true. But we want to be sure that the parenting time is of quality. What does that mean? That the parents are able to engage with the child during the parenting time, that they're not just sitting there too afraid to say anything, too afraid to touch the child, too afraid to really get involved with the child because they're afraid that the foster care worker is watching them and going to report something negative. We want to be certain that we're not limiting the parenting time to the time prescribed in the order or the time prescribed by the agency, that minimum once a week. But referring back to the chart that's in the foster care manual with respect to how frequently the parenting time occurs, we want to be sure that they have opportunities outside of that time frame, as Vivek explained earlier. Doctor's visits, school conferences, family reunions, any opportunity that you can argue your parents should be allowed to have parenting time is fair game and really should be argued. So at every single hearing, you're not going to have a lot of hearings between the prelim and trial, but at every hearing opportunity, you want to revisit parenting time. And always be asking for it to be expanded, either in duration or frequency, and also in nature. So if it's supervised, you want to be asking for it to be unsupervised. Going back to what we were talking about earlier about the court rule requiring that there be harm to the child if it's going to be let me restate that. Parents entitled to parenting time unless it's going to be harmful to the child. And if you can't make the argument that it's going to be harmful to the child, and by you I mean the agency, then the parent is supposed to have the parenting time. If the child's safety can't be assured, even if supervised, then that's the instance where the parent shouldn't have parenting time. And even then, there has to be a professional assessment as to the harm that would befall the child. It has to come from a professional such as the child's therapist or a psychologist, someone who is duly specialized and credentialed in mental health.
And Tracy, if I could just add on the parenting time issue, the harm standard right now only applies through disposition. There's actually a case at the Court of Appeals in Reed Laster, which holds that after disposition, it changes to a best interest standard, that a court could suspend or deny a visits based solely on its finding that it's not in the child's best interest to visit, which is a very different and lower standard. It's just a sort of bad, I think it's a bad decision, and one that hopefully we can change, but would have to go through the Court of Appeals. So if you have a case where a judge denies your client's visits at the dispositional stage on a best interest finding, what I would do is say that you believe that the harm standard should apply. Reserve the issue. We can help you frame it if you need to, and then eventually, either appeal it right then or right to terminate it. You could raise the issue in a termination of a parental rights case, and our hope is that the Court of Appeals may reconsider that. I think that there's flaws in the decision, but we were unable to track down the client at the time of the decision to be able to challenge it to the Michigan Supreme Court.
So it's the harm standard's only through disposition?
Correct.
Right.
Which is where we are right now. I'm sorry, what was your question?
I thought you said adjudication.
Well,
Disposition.
Yeah, right, so that case dealt with the dispositional stage, so usually the adjudication and dispo in most counties are like
Ours are two separate hearings, 30 days apart.
30 days apart. Yeah, so I think the case actually holds that it's a dispo that the new standard applies.
That the what standard
The
applies?
best interest standard
So
applies.
through adjudication,
Through adjudication.
Yeah,
for harm.
yeah.
What was the case on that?
It's on the
Last
previous
time.
slide.
Yeah.
Laster.
Thank you.
Oh, one more, forward, yeah, on the bottom.
The legislature's considering a
Okay. So we've already touched on a great deal of this. So just in summary for placement and parenting time, they're at the heart of the case. And so they really should be approached with a very strong sense of urgency and seriousness. You want to promote proximity of the placement to the child's home. You want to promote the child being able to maintain routines and customs that the child is already accustomed to experiencing. And you want to promote not just the parent-child bond, but what should be added here is the sibling bond. Advocate for frequency in parenting time and look to policies. Vivek's going to discuss a little later about this case of Henry Rood in a little bit more detail, but Henry Rood is the case that really links DHHS's, I said that right, policies to the law, and it can be a very, very effective tool. The policies, all of them, are at this website here. Services and conferences. So we talked a lot about reasonable efforts already. Reasonable efforts to keep in mind are not just for removal, but for return home. And we're still at the stage where we're preparing for trial. So we're not necessarily focused on removal, but we're more concerned about, we're not necessarily focused on achieving a permanency plan. What did I just say a minute ago? Let me restate that. Reasonable efforts are for preventing removal and achieving permanency or reunification. I think I did say it right the first time. So here in between prelim and adjudication, you're focused mainly on returning the child, getting the child back in the home of the parent, because the permanency plan really isn't official at that point, because there is no official permanency plan, because there's no adjudication yet.
Well, I would disagree with that because there's two types of positions. One is temporary jurisdiction, and one is termination and initial disposition. So the typical case is the temporary jurisdiction. That is the reunification.
What I'm trying to say, which is really very inartful, and I apologize, is that until there's a trial and disposition, there's no official permanency goal. And the federal law is looking at reasonable efforts to prevent removal of the child from the child's home and reasonable efforts to achieve the reunification as a permanency goal. And so before trial, the general goal is to try to get the child back with the parent, but it's not technically reunification as far as the federal goal is concerned. There's probably room for disagreement on that, but that's just the way that that's what I meant by what I said. That's the way I'm looking at it. What do you think?
Oh, no, I think the default is, unless it's a petition for termination at initial dispo, the default is the permanency goal is reunification. I mean, I think it's maybe a play on words, but like any reasonable effort needs to be directed towards reunification as opposed to another goal. The exception is maybe initial disposition termination petitions, but then under our laws, within 28 days of a finding that reasonable efforts don't have to be made to reunify, the court has to have a permanency planning hearing. And so I think triggers a whole sort of separate process that is.
But is there a permanency goal in place before trial? I think that's where Kim and I are following it.
I don't know. I don't even know why. It doesn't really matter.
It's kind of a play on words, because even at
The reasonable efforts have to be directed towards
they know,
reunification.
like the referee knows that temporary jurisdiction.
Correct.
Means we're going towards reunification.
Correct. And that's just the default unless someone else says something otherwise and the court makes a contrary finding.
Yeah.
Could I ask you a question about this whole area of reasonable efforts is like a glaring hole in the law. And just recently I've been getting must make reasonable efforts to deal with these kind of parents. So they kind
Right,
of
they link.
intertwine each
And then
other.
the other one is
Mhm.
active efforts, which in ICWA and MIFBA cases, and that's a heightened standard of agency obligation that needs to be made. So I want to make sure people
Yeah.
realize.
So
Michigan
two things.
more than likely is not complying with the ADA, just like Massachusetts wasn't
So the
complying.
bench doesn't even.
Betsy, can you share that resource with Vivek so he can get on the parents' attorneys listserv?
Go to the parent training listserv, I'll post it next week.
But also, to your point, Kim, and this is something that I touched on just a little while ago during Vivek's presentation, reasonable efforts. Remember we're back in law school where we were taught what reasonableness means. It's an objective standard. And I think by even an objective standard, if someone is cognitively delayed, if it's established by the evidence that someone has some deficits, what's reasonable for that person is not going to be reasonable for the next person.
Correct.
And so you have to make that argument, even if it doesn't fall within the prescriptions of the ADA.
Making that argument, but here's what it is, everybody's so ignorant about the subject. They get it on some baseline level. So I say, you can't send my client to this parenting class and lecture at it. They have a cognitive impairment.
And maybe he can't even
I say,
read.
you can't send this person to a therapist for individual therapy, and they just sit down and talk therapy unless this therapist is specifically trained. So I'm making those arguments, and what's happening, because people don't know, and in my county, they get it on some level, and we've seen these guidelines, and they've been passed along to the bench too, but change is always slow, but in the meantime, I got a client that's in the system, but what's happening is the bench is looking at me like, what do we do? And then the caseworker is saying, I don't have such services. Do you have services you can, so it's being bounced back to me to serve. They're saying, do you know a service that I could send this person to?
Well, that's really a good segue because we're,
I don't want
yes
to take
ma'am.
up all of your time, maybe we can talk, maybe we have some.
Mhm.
Now that it's become a federal
Okay.
issue, the ADA
That's
is
fine.
now,
That's good.
everybody needs to know
And the
is
prosecutor,
active in child welfare. They have asked for complaints. The people who did the investigation in Massachusetts have sent out the call saying, we want to know all over the country if the ADA is being violated in child welfare in your particular case. We're not talking systemic like the whole state of Michigan. We're saying your case. One case got to change. In
And
the
you gotta
United
see-
States of America on this, it can happen.
CSTS is saying there's no services for these people that are 60 IQ. You gotta be 55 IQ or you're slobbering over yourself, what we used to call retarded. So there's a huge systemic problem with it, but recently, the prosecutor was emboldened to argue that because I didn't say the word ADA, claimed, close quote, that I did not sufficiently put the system on notice, which is ridiculous.
Yeah.
One
And-
thing to keep in mind with IQ tests for proving these things is that IQ tests are, like many tests, more accurate in the middle than on the extreme outliers on either end. And the difference between, let's say, talking about death penalty cases, a 75 IQ that qualifies and an 81 that doesn't, is literally inside the margin of error of switching who delivers the test. That at low ends, you can get as much as a 10-point swing just from having a different person give the test because it's based on their demeanor when they ask questions, and it's often very hard to control what signals you're giving. It's a very good test when you're trying to evaluate if someone's an 89 or a 110, but a very bad test if you're trying to evaluate if someone's a 55 or a 62.
Okay, we have one more question over here and then we're going to break for lunch. Yes, ma'am.
Regarding the petition and reasonable efforts, what if, and I've seen these cases, what happens if the parent molested the child and there's a termination request at the initial petition? Do they still, is the goal still unifying with that parent? Are there,
I would imagine,
give any parenting time or any?
So
I
I
would-
argue that they haven't terminated yet. Now, when you're saying sexual abuse,
Well, that's the worst case. I mean, we've
okay,
had several
in a
where they
sexual
had
abuse
termination.
environment, it is hard. I mean, the benches, you could
So this is where I think as a community, we need to be sort of anchored in the law, right? So if you look at the law, there are specific aggravated circumstances that are contained, which then, so in MCL 722.638 and in 19A, they talk about the specific circumstances in which the agency no longer has to provide reasonable efforts because of the severity of the allegations. And so I would think that in your situation, that would be, that's, I can look it up.
Yeah.
Define
It is
contact
638, yeah.
and penetration. They do not have to file a mandatory termination request if there's only sexual contact. That's really clear in the mandatory termination statute, which is 722.
But there's hold on, but there's a distinction to be made between what's mandatory for filing a petition and whether the agency is absolved from reasonable efforts responsibility.
The same body line, I think, is in the reasonable efforts law as well. I don't know why the legislature did this, but they did.
So it's abandonment of a young child, criminal sexual conduct involving penetration, attempted penetration, or assault with intent to penetrate, battering, torture. So you can go through the list, but.
So just mainly to wrap up, we talked about parenting time and placement as two of the cornerstones, moved into services and out of court, moving into services and out of court conferences. We want to remember that the requirement for services is that the services are tailored to meet the presenting problem that brought the children to the attention of the court and to CPS to begin with. So even though we're not quite at adjudication yet, we're still at that phase where we're preparing for adjudication. If you've discussed with your client that your client should participate in services, which is what we were discussing a little earlier with Vivek, you want to be sure that those services that your client is going to participate in are tailored towards remediating the problem that brought everybody to the court to begin with. Because if you don't do that and you just allow your client to do anything that the agency is suggesting, what will likely happen is your client will be held to complying with those services, even if later on it hasn't been determined that it's needed by the dispositional order. And if your client does not comply with the service plan, that could ultimately be used down the road to meet the statutory basis for termination of parental rights. So it really starts here. So if you and your client determine that he or she should participate in services pre-adjudication, there are lots of reasons why he or she should, lots of reasons why not. You need to make a determination case by case. If you determine that he should, make sure that it's tailored to addressing the problem that brought the family to the attention of the court to begin with. And in most cases, the goal is going to be reunification. We talked about that just a little while ago. So I'm going to move on to, well, this is just a reminder of something that we discussed earlier. It's easy for me if I can remember, it's easy for me to remember things in quips. So I'm saying remember to seek and cite. Whatever it is that you're looking for, cite some authority that will support why the court should give it to you. That relates not just to parenting time, not just to placement, but also to services. Okay. Conferences. This is probably the most underutilized cornerstone in cornerstone advocacy. And it can also be the most helpful if you employ it, because most of what it is that we do in child welfare that can actually help families doesn't happen in the courtroom. It happens before you get to the courtroom, and it happens in between court hearings. You don't need to wait until DHHS calls for a family team meeting. You don't need to wait until you get to court and just minutes before the hearing to discuss with all the parties possible negotiation or settlement, or to discuss anything of import that's relating to the case. You should be having, as frequently as you can, conferences with people you determine have something that they can contribute towards your overall objective with your client.
What are family conferences?
That's a really good question, because they're really whatever you determine they are. If you want to make an argument, for instance, that that the child who's currently in a foster care placement should be placed with a relative, well, you can have a conference with that particular relative and all of the other relatives who might want to step up as secondary and thirdary, if I can make up a word, options. Have a conference with them to determine who should be presented to the agency and to the court for possible placement. And then you can have another conference with the agency with those same people. And by conference, I don't necessarily mean something as formal as everybody getting into a room, but it can be as simple as just picking up the phone and talking to people, even on a conference call. But going back to what I said earlier about having more information about the case than anybody else, this really speaks to that. If you're talking to the people who are, by and large, on the outside looking in, as far as relatives are concerned, and even service providers that are working with your parent, if you're talking to them regularly, you're going to have a lot of information. And usually that information is something that can sway the department the service specialist. Because at the end of the day, both CPS and foster care workers are overworked. They have extremely high volume cases, and they have really big case loads. And if you can present to them a reasonable option for what it is that they just routinely argue or recommend, they'll listen. So here are some examples of meetings that you can have with the DHHS service provider, with their service providers, their the contracted services, school personnel. You can have meetings to discuss the assessments before they are admitted into evidence, meetings about visitation, et cetera. Really anything that you think is going to promote the achievement of your client's goals, which in most instances is going to be reunification or placement of the child, you can be talking about outside of the hearing. Because you really don't have the time to really thoroughly discuss these issues when you're at court. And there's too much tension associated with the court hearing for people to have the advantage of sitting back and really thoughtfully considering these issues.
Brings up this issue of the difference of practice in different counties. Like in our county, the agency submits their reports and any documents directly to the court. There's no formal evidentiary admission on the record. And I understand, because I was talking to some other counsel that practices in Wayne County, that they formally put the caseworker on the stand at all these reviews.
By and large in Wayne County, the service specialists testify, but that's not always the case. It depends on the jurist, especially the judge. If there's a judge involved, sometimes the judge won't want to entertain testimony. And the point that I'm trying to make is that before you get to the hearing, you've got a long span of time oftentimes between the pretrial and the trial. Before you get to that trial hearing, if you're contacting the decision maker, which at that point is the CPS investigator, and trying to just have a conversation with that person, then you can affect how the testimony comes out, if at all. You might be able to come to a negotiated settlement.
So that's the decision for me a lot of times is it's my default to try to talk to people. But what I've learned over the years is when I talk to people, that gets them ready for trial. find myself, you know, if we're in a trial posture,
Mm-hmm.
I'm less likely to talk to people. Or even in a dispositional review, if I talk to them, because 9 times out of 10, they made up their mind a lot what they're going to do, when it's a lot of covering your ass environment. As opposed to me going to court and revealing something that occurred. And I'm just talking about being a practitioner.
Mm-hmm.
I have to deal with all these personalities like you do too. And, but if I, you know, I mean, I know these people, I've worked with them for years. If I feel like I can talk to a person off to the side, I will. But a lot of times, the system doesn't give room for the CPS worker or the foster care worker, because they have to answer to their supervisor.
Mm-hmm. And so the supervisor might be one of the people that you would want to get into the meeting. One of the things that I can say from my personal experience as a former foster care worker is that I do not want to come up against an advocate for the parent in a contested hearing. I don't want to do that. And so if I can in between that hearing have a discussion that might bring the case to a reasonable resolution, I want to do that. The reason why I believe there's not a lot of that occurs, that the service specialist has this kind of tunnel vision towards the objective of jurisdiction or of removal of the child or whatever adversary outcome you're dealing with. I believe the reason why that is the case is because that's just what happens. That's just the practice. That's the custom. But it's not customary to pull that specialist aside, appeal to that specialist as a professional, and engage them in a reasonable discussion. If you have more than one person at the table, it's a little more difficult to maintain an unreasonable position. And if you have more than one person at the table, it gives cover for the specialist. So if you invite the supervisor, it gives cover for that specialist to be reasonable. But the idea that I want to stress here is just to be talking, be active outside of the hearing. That's the takeaway, whether it's with relatives or the professionals involved in the case. And you always want to have your client involved in those discussions. Yes, ma'am.
We just changed our NA attorney setup, so now it's run out of the PD office, and the parents.
What's the PD office?
We have a brand new
Oh,
PD office.
okay.
And they get to handle, so you have the prosecutor and the child's attorney, everybody works together against the parents. And the problem is now that we're paid quite a bit less than minimum wage. So to attend all those conferences, you would make like $2 an hour.
That is a challenge, isn't it? And most of us, even though we're all such wonderful people, and I mean that, I'm not saying that tongue in cheek. Most of us go into the law because we want to make a living. We'd like to do it as something that we enjoy, but we go into any endeavor for our employment because we want to make a living, and so that is a challenge.
You can't stay at
We get
business.
paid,
You can't
we
make
do
money.
not get, we will
Yeah,
not get paid for this.
some
We get
counties-
paid
some
$60 for a court hearing, $180 for a trial, $40 for a GA. We don't get paid for FTMs, nothing.
So here's a thought. If you have to be there anyway, how about ask that the parties come to court a little earlier? If you give them in advance what it is that you're going to talk about, then maybe you can accomplish the same objective. Just not
They
in
had a case where the mom is, it's front page news, the one child died, the other child was looking to be removed, and the child was removed, but my client agreed to it. And they have all these FTMs, and I submitted a bill for it, and I just got my check back, and I am not paid for it, and these were mandatory. I mean, my client wanted me there. It was.
I've been to FTMs where things could have gone down that would have changed things drastically, but for my having been there, and they send back my bill, they're sorry, we can't do this. Are you
But
kidding
you
me?
can tell me, there's no law that says your client has to go to an FTM.
That might be the resolution, because they pick up.
And they'll
I mean,
make
Well, the FTM is going to go on with or without the client, so I think it's probably better to have the client there.
Oh, I
But
would never send a client without an attorney. They are so mistreated.
Yeah,
I've
they
seen
take
them
them
do
off.
it in front of
They
me.
won't
I
have
can
them up.
imagine what they do it to it when I'm not there. Especially if it's a private care agencies.
But-
Obviously DHS personnel is
They say
doing
that
much better.
what happens at the FDM, you sign a confidentiality, that
Yeah.
everything's confidential.
Oh, yeah.
Then they quote it all in the
Court
court
report, yeah, yeah.
So
Wait,
I
no,
don't know that I would want my client there without an attorney.
Well, I generally don't let, I mean, we go because I wanna hear what they're saying, but I certainly wouldn't let, if we were gonna fight adjudication on a tough case, no, obviously they're not talking, I'm doing the talking, but it just, you still get up to where there's some counties that don't know what their own policy is, and they think the attorneys can't be there. You'll get some of them that have that old rule from 10 years ago still in their head, but
Or they
Yeah.
schedule it, they don't take into consideration your schedule.
their schedule,
So,
they don't.
so you have to take all of these things into consideration. There certainly is a cost-benefit analysis that we can't deny. Keep the conferences in mind, though, because if they're happening enough, and then the people who are making the decisions about payment are hearing that they're happening, and hearing that things are being resolved faster without going to court, it's really a benefit to the policy, not the policymakers, but it's a benefit to the decision makers who determine how money is going to be spent, because they're saving money.
So I
It
know
costs a lot
some-
more to have a trial.
For instance, they're real into their form from the FDM. They like to have that done.
Mm-hmm.
And they want you to sign it. They'll tell you that it doesn't mean you're agreeing with anything. As a general, my policy is I don't sign it, even when I'm an LGAO. Even in some small instances that it's been a good meeting. Because most of the time, it's for them to say that they had the FTM and look at you, you were even allowed to participate. And they've got their mind made up. It's really not a team.
But keep-
So I feel like it's really skewed, the whole process is really skewed, but
Keep in mind.
It's not lost on me, I mean, I understand.
Well, just keep in mind that it's not DHHS exclusively that you want to be talking to. You want to be talking to anyone who can have an impact in the decision making. So I'm mainly focusing on DHHS and relatives, but that's not an exhaustive list.
But at least when you're not getting paid, this is what I think the backup is a lot of people are in that situation, is that you tell them, yes, you can go, but I want you to have at least one trustworthy person that you can trust with you, preferably two, so they look like they have analyzed. That does, I would think, reduce some of the menace and misinformation.
That'd be real, that's smart.
And
That's a good
so
idea.
they should never go alone though, because they will say things happen and it just.
Will they allow them to invite their support, family members and friends?
But we need
In
to
our
tell them to
county.
go, yeah.
But
Well, whenever I go and they ask me what my role is, I say I'm the support person. They know I'm the attorney, but I'm the support person in that context, because when I go home, I'm mom, I'm wife. You know, I have other hats that I can wear, and just because I'm an attorney doesn't mean that I'm the attorney in the FTM. Right? I'm done.